OSC's disclosure unit receives allegations of wrongdoing from current and former federal employees and applicants for federal employment. Federal law establishes a unique process for these disclosures, which is intended to protect the confidentiality of the whistleblower and ensure that the allegations are investigated and corrected as necessary. When a whistleblower disclosure is filed with OSC, an attorney reviews the allegations to determine if there is a substantial likelihood of wrongdoing. If so, the special counsel may require the head of the agency involved to investigate and provide a report of the findings. After the investigation, the special counsel determines whether the agency's findings are reasonable and sends the agency's report and the whistleblower's comments to the President and Congressional Oversight Committees. OSC also places the documents on its website for the public. Throughout the disclosure process, whistleblowers may remain anonymous. What kinds of allegations does OSC review? Violations of law, rule, or regulation, gross mismanagement, a gross waste of funds, an abuse of authority, a substantial and specific danger to public health or safety, and censorship related to scientific research. What kind of information does OSC need? Your first contact from OSC will probably be an introductory email from the attorney assigned to your case. All whistleblowers who reach the disclosure unit will also receive a phone call from their assigned attorney to go over the details of their case. Because the disclosure unit doesn't conduct its own investigations, we need specific and substantial information to determine whether to request an investigation. Whistleblowers should be prepared to provide who, what, where, and when, and share supporting documentation. Usually, speculation and broad, generalized allegations will not result in a referral for investigation. Referral decisions are made within 45 days. Can you share with us some insight into the kinds of allegations the disclosure unit receives?
The types of allegations that the disclosure unit reviews are often influenced by current events. A prime example being federal agencies' responses to COVID-19. At the beginning of the pandemic, the Special Counsel established a COVID task force to streamline OSC's processing of COVID-related matters and maximize our efficiency and effectiveness. The Disclosure Unit, or DU, continues to receive a wide variety of allegations due to the unprecedented nature of the pandemic. DU reviewed many allegations related to potential outbreaks at certain agencies, offices or agencies late to authorizing telework permissions, and the establishment of health and safety protocols related to COVID. DU saw an uptick in the summer of 2020, where the allegations related to return to work procedures as the country was trying to reopen following many lockdowns nationwide. During the fall and winter months, we generally saw more cases related to the lack of enforcement of health and safety protocols within office settings, such as mask wearing, social distancing, and sanitization procedures. As new issues or changes have arisen throughout the pandemic, the cases that DU receives seem to follow the times. Due to the dynamic and fluid situations the pandemic has presented, DU had and continues to have to review each case specific to the facts and field the unique circumstances as we encounter them. Thanks to leadership and our dedication to these cases, the COVID task force has been a tremendous success.
How do OSC disclosure cases make an impact for the public?
OSC receives many interesting and impactful cases each year. For example, the Disclosure Unit recently closed a case from a whistleblower who alleged that the Social Security Administration was not always informing certain widow or widower claimants who filed for benefits of the possible financial detriment of not waiting until full retirement age to file for benefits. We referred the allegations to SSA for investigation. The SSA OIG, Office of Inspector General, conducted an audit and substantiated the allegations, confirming that claims takers did not always follow SSA policy, requiring them to inform widow or widower claimants how they might be adversely affected. SSA identified approximately 21,000 beneficiaries who were entitled to widow or widower benefits before they reached full retirement age. Had SSA informed them appropriately, they may have been eligible for additional widow or widower benefits if they had filed later. The OIG determined that of 21,000 identified widows and widowers, 1,938 would have been eligible to receive $12.8 million in monthly benefits had they delayed filing for benefits until full retirement age. Additionally, 1,615 widows and widowers could receive approximately $42.6 million in benefits over their remaining life expectancies. Based on these findings, SSA committed to notifying all of the affected claimants of their option to continue with their existing benefits or withdraw and resubmit for widow or widower benefits. SSA also instituted new training and control measures to ensure that employees were alerted to their obligation to inform widower or widow claimants of these options. The whistleblower's courage in coming forward, combined with the disclosure unit's expertise and the special counsel's authority, corrected the situation for thousands of past and future claimants, and is a great illustration of how OSC's disclosure process can work to effect positive changes for agencies from a policy standpoint and help make affected citizens whole.